The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is State versus Dew. I want to note that Justice Berger is recused in this case. We'll hear from the appellant.
May it please the court. I'm Dan Schatz with the Office of the Appellate Defender, and I appear today on behalf of Jeremy Dew, the defendant in this case, which presents two issues related to the law of assault. The first issue is whether and when hands can be a deadly weapon as between two healthy adults in the context of an assault charge. The second issue is the unit of prosecution, or how to tell when there's a single assault that inflicts multiple injuries as compared to multiple assault charges. And I know that second issue is also presented in the next case your honors are going to hear, the State v. Prince case. And so I'm going to start with the hands and feet in case we run short of time, because I know you'll hear more about the other issue. I'd like to reserve about 5 minutes for rebuttal. And before I get into the law regarding hands and feet as deadly weapons, I have to apologize to the court. In preparing for this argument yesterday, I finally realized that I've actually been misreading the record the entire time this case has been going on. So anywhere in my brief where I talk about hands and feet, it should actually be hands and fists, because that's what the indictment, the bills of information alleged, and that's what the jury instructions talked about. So I apologize in that regard, but I don't think that should affect any of the legal analysis, because throughout the case, I don't think there's really been any factual or legal question that the serious injuries were actually inflicted by Mr. Dew with his hands, whether open-handed or fists. I don't think that's a distinction that really is meaningful in this context in any event. And I need to start with the case this court has decided since the briefs were filed, which is the State versus Steen case, because that case obviously has a significant impact on the question of how hands can be considered as deadly weapons. And so I sent that in as a memorandum of additional authority. And prior to this court's opinion in Steen, the last time this court had really addressed the issue of hands as deadly weapons was in the Lang case in 1983. And at that point, the court cited with approval earlier case law that said that as between healthy mature adults, hands and feet are generally not deadly weapons, or are not deadly weapons, because ordinarily death or grievous bodily injury would not be expected to occur from an assault with hands. And Steen, in the context of the felony murder statute, in the context of General Statute 14-17, said otherwise. And I think applying Steen to an assault case creates a lot of problems with line drawing between different categories of assaults, and creates a risk, and I think Justice Earls alluded to this in her dissenting opinion in Steen, that the crime of assault with a deadly weapon inflicting serious injury would kind of swallow up assault inflicting serious injury and assault inflicting serious bodily injury if hands and feet can be deadly weapons, because really what that kind of leads us with is, if any implement that causes a serious injury in an assault is a deadly weapon, you're never going to have just a simple assault inflicting serious injury. And I think historically, an assault with hands that is the classic non-deadly weapon assault. So, this problem is particularly acute when you're looking at an assault, if the state is also right about the second issue and about how each separate act in an assaultive transaction, if you will, can be a separate assault. So in this case, I want to call the court's attention, particularly in terms of thinking about this issue, to the charge where Mr. Dew was convicted of assault with a deadly weapon, inflicting serious injury for punching Ms. Davis and breaking her nose. That was one of the specific charges. And so what you have, if the opinion below is correct, is that punching somebody in the nose and breaking their nose is assault with a deadly weapon, inflicting serious injury. And what that would also mean is if you threw the exact same punch, but the person turned their face in time and you hit them in the cheek and it didn't break their nose, that's going to be an assault with a deadly weapon, because the person throwing the punch has used his fists in the exact same manner. It just didn't cause the actual injury. But again, the test, as it has always been espoused by this court, is not the injury that actually occurs, but what injury is reasonably for, what is the injury that would ordinarily occur or normally occur. And so again, the test can't depend on the question of what injury actually occurred. And frankly, historically, one adult throwing a punch at another adult has never been viewed as an assault with a deadly weapon. And so what happened prior to Steen, this court had what seemed like a bright line rule and bright line test that as between healthy, mature adults, an assault with hands is not going to be an assault with deadly weapon. And I think in the Lang case, I think to be honest, I think this court's majority opinion in Steen may not have read everything in Lang the way I think it ought to be read. In Lang, the court went to great lengths to describe the victim as laboring under the disability of intoxication. That it didn't just say that the victim was intoxicated, but made a point of describing that as a disability. In Lang, the court also emphasized language from its earlier case from 1859 in State versus West, and from the Court of Appeals in a case called State versus Sally, that basically said, in West in particular, the court was very clear, even if death results, an assault with hands by one mature adult against another is not going to be a deadly weapon, because ordinarily death would not be expected to occur in that situation. And so I think what has happened, and what particularly happened in the Court of Appeals in a number of cases that led up, that the majority cites this in the Steen opinion, is that the Court of Appeals started looking at the manner of use in a much too fine-grained level, at too great of a level of detail. In the West case, when this court started with that, the manner of use was simply assaulting somebody with your hands. And it didn't really matter the manner of that assault. And there's also a case I cited in the brief from the early 1900s. It was a dueling case where the two parties had agreed to meet each other and fight with hands and fists and no other weapons. And this court said, as a matter of law, that could not support a dueling charge, because as a matter of law, there was no deadly weapon, which was an element of a dueling charge.
Mr. Schatz, let me see if I can get you to help me with something here. Of course, in footnote number 3, as the author of Steen, let me direct your attention to footnote 3, which basically says the only issue in that case was whether in that case, hands and arms could ever be a deadly weapon, that we were not resolving the issue of whether there was, matter of fact, we had that situation. What about the facts of this case should cause us to conclude that bodily appendages. In writing Steen, I had the same trouble that you described in writing the brief in terms of saying the right thing. I think I had hands and feet repeatedly represented arms. What about the facts of this case, which is toward a decision in your favor with respect to that?
Okay, well, first of all, I think we want to start with the point that there were two separate convictions for assault with a deadly weapon inflicting serious injury. So the one I was just talking about, where the serious injury is the fractured nose, if you view that as a separate assault from the other assaults that were charged, that's simply an example of somebody punching somebody in the nose, and that was the assault, and that was how the hands were used. And I just don't think our case law supports the idea that a hand, when you punch somebody, you're using your hand as a deadly weapon. And I want to say, I think in this context, not only does that have implications for the law of assault, I think it has very important implications for the law of self-defense. Because if you are a person who throws a punch and hits somebody in the nose and their nose breaks, and that means you're using your fist in a way that constitutes a deadly weapon. What that means is you are using your fist in a way that is likely to cause death or grievous bodily injury. And so flipping it around, if you are a person who thinks they're about to get punched in the face and reasonably thinks that, in other words, that belief is reasonable as well as actual, if being punched if a punch to the face is a deadly weapon use and is something that the law says is likely to cause death or grievous bodily injury, that means that you are entitled to use deadly force in defense. In other words, if you're about to get punched in the face, you can pull out a gun and shoot somebody. And I don't think that has ever been the law of self-defense, and I don't think it has ever been the law in this state of assault. And of course, I think those two things have to go hand in hand. Because
why would not this best be left to a jury, as in the case here, where there was a 5-inch differential between the alleged victim and the defendant? We don't know how much the defendant weighed, but we know that the alleged victim weighed 140 pounds, and leave it to the jury to decide whether or not hands and feet, and of course teeth is involved here as well, would be deadly weapons here.
Well, Your Honor, I think at some level there has to be a minimum showing, in any case where there's ultimately going to be a jury question, there's a threshold level that the trial court has to make sure it is enough to support that conclusion. And again, when the assault is a punch to the face, our case law has just never allowed that, and there has to be a certain amount of notice and certainty in the law as to what constitutes the felonious conduct, what makes the use of a hand a deadly weapon. And prior to Steen, I think we had a easily applicable bright line test that, as between healthy mature adults, hands were not a deadly weapon. And what you do is, now we have, there has to be some level that is not enough, because any use of force could theoretically have an unexpected outcome. So, if throwing a punch to the face can be considered a deadly use of someone's hands, where do you draw the line? That's the problem with that. I think it's replacing a bright line test with kind of a vague, fuzzy, and everything can't be just a question for the jury. There has to be some level where the law provides a certain minimum notice, what constitutes a weapon. Or
why you say it's a problem, it could also actually be looked at arguably as being an aid in terms of the fact that if you have these matters as being fact specific, while on one hand a bright line rule may be appropriate, On the other hand, though, to use a colloquialism, it's not always one size fits all. So as a result, let these matters go on a case by case basis and let the reasonable person decide a group of 12.
Well, I think, Your Honor, if you flip this question around and think of it again in terms of the law of self-defense, I think our case law, again, what that means is it's always going to be a jury question, even if an unarmed person, a person thinks they're about to get punched in the face, the assailant is completely unarmed, and the person using defensive force, their belief, may be reasonable, but it may in fact be inaccurate. But again, it doesn't give the notice, that person is going to, not have the proper notice that he can't use deadly force in that situation. But I think
on this question, hasn't the legislature also spoken? And hasn't the legislature said that we will have one level of punishment for assault with a deadly weapon and a different level of a punishment if assault doesn't involve a deadly weapon? And so it isn't just up to the jury to decide. There's actually some statutes involved.
Yes, Your Honor, I would certainly agree with that. And I think that this gets back to what I was saying. There's a line drawing problem. If anything that inflicts a serious injury can be a deadly weapon, and again, anything that's likely to inflict a serious injury, and so obviously, I think that creates serious problems. And again, I think when you have a multitude of assault sort of categories, and the case law, by the way, says that those categories are all about distinctions in punishment, and there's essentially one common law offense of assault, and I think it creates serious line drawing problems, and a judge is supposed to be able to, as a matter of law, recognize a point where the evidence is simply insufficient to sustain the state's burden of proof, and that's true in any kind of charge. There's always some threshold level the state has to make before it goes to the jury.
Excuse me. Oh, go ahead, Justice Earls. My apologies. Well, I'll proceed. To your point about whether there needs to be a threshold to get to the jury, while it wasn't part of the charge, there is testimony that the victim was strangled until vomiting. Would that not be enough for the judge to consider that the jury might need to make that determination of whether hands are deadly weapons?
Well, Your Honor, the answer to that is that the state charged that separately as assault by strangulation, and the jury acquitted Mr. Dew of assault by strangulation in this case. And again, this gets to the overlap between this issue and the issue of distinguishing between one assault and multiple assaults. But again, here in this case, each different, there were 5 different assault charges based on what happened in the trailer, and the jury acquitted Mr. Dew of the assault by strangulation and one of the 2 counts of assault on a female, misdemeanor charge. And so I don't think in this case, the way this jury was instructed on all of the different charges in total, that would be a viable way to get to this. And again,
well, let me pursue this just a little bit, just so I understand it. But at the time of the charge, the sending this to the jury, the judge would not know whether the defendant would be convicted of that or not. So the question I'm really posing, would the fact that was in evidence not be enough for the question of deadly force with hands with respect to any of these kinds of things be appropriate for the jury? Or are you saying that no, since there are separate offenses specifically stated by the legislature, that's how it should be handled, not a jury question?
Yeah, I think it's correct where there are separate charges, but also, again, the serious injury in this case was the for one charge was the fracturing of the nose, and for the other charge was rupturing the eardrum, and the strangulation did not cause those serious injuries. If, again, especially given the way that each one was broken down to be alleged and charged and presented to the jury as a separate charge. So I think that is the answer I have for your question.
That's helpful.
And so I think at this point, unless there are more questions about hands,
I had one more.
Okay.
I had one more, and I know you're about to transition, but it could be an appropriate last question before you do that. I know that you concentrated primarily in your oral argument just now and in your brief on hands and feet, and you've said today hands and fists. However, when you talked about it in your brief, you talked about the case law on hands and feet, but then you draw from the case law that the case law applies to hands, feet, and teeth. Of course, nothing in the case law, particularly in teeth, you kind of stretch the case law to arguably cover teeth. Do you have any case law that expressly says that teeth are not deadly weapons against a healthy adult?
I don't, Your Honor, but I do have a factual point, and this is kind of similar to my answer to Justice Berenger's question, because what Ms. Davis testified to was that what broke her nose was not the teeth, but the punch. If you look at the last line of page 93 of the transcript and turn over to page 94, so the question was, the first question, it starts, where your nose was broken, was that from a fist or from a head? And the answer was, he punched me. So Ms. Davis very specifically testified that what broke, and she earlier had talked about the biting of the nose previously, and she clearly in her testimony as a factual matter, again, it was separate, and it's very clear from her testimony that what broke her nose was a punch from Mr. Dew's fist. So it's more that a factual answer than a case law or legal answer to your question, I think.
So are you saying that teeth don't have any involvement here at all now in terms of being deadly weapons, and we don't have to consider teeth?
Certainly, based on Ms. Davis's testimony, that's what I would say. It was alleged in the information, but I don't think the evidence supports the teeth as a deadly weapon causing the serious injury that was specific to that. And teeth weren't alleged with respect to the other assault with a deadly weapon inflicting serious injury charge.
Okay.
So turning to the other issue, the opinion below in finding that each different act within each of these different assaults were actually different assaults relies heavily on a case called State versus Rambert. But Rambert was not an assault case. It was a multiple charges of discharging a firearm into an occupied vehicle. And so when this court in Rambert was addressing what the unit of prosecution for that offense is, discharging a firearm happens virtually instantaneously. You pull the trigger, the firearm discharges. Assault has always been different from that. And so this court had not really imported Rambert into its analysis for multiple assaults. The Court of Appeals first did that in the Littlejohn case that's cited in the brief. And there was no real discussion about whether that was, wait, this is a different charge. The Court of Appeals, if you read the Littlejohn opinion, it just sort of takes it as a given that Rambert would apply, but there's no analysis of why that would be so or why maybe it shouldn't be so. So I think that kind of just crept into the law of assault without the really of being fully thought through in terms of what it would mean to assault. And so then you have these sort of divergent lines of authority in the Court of Appeals that are discussed in the brief and in the briefing in the Prince case that's coming up next. They're discussed probably at even a better level of detail and explanation. And so they all talk about the test for multiple assaults being whether there's a distinct interruption. So where one assault is over and then a second assault starts. Rambert was talking about whether there were distinct acts. And so, they both, involve the word distinct. They're looking at distinctions, but what the word distinct is applying to are two different things there. The distinct interruption test first comes into the Court of Appeals case law in the Brooks case, which doesn't mention Rambert at all and doesn't apply Rambert, and is one of those cases that says the state has not shown a distinct interruption. I'm winding down a little, so I want to talk something specifically about the facts in this case, because the state in its brief discusses the possibility that the assault in the car is a separate assault. And I would agree that there's a distinct interruption between what happened in the trailer and what happened in the car. But I don't think the state has shown that there was an assault with a deadly weapon inflicting serious injury in the car. I think all of the evidence is best read that the broker knows the testimony is unequivocal that happened in the trailer. And Ms. Davis's testimony, I think, is absolutely best read that the ruptured eardrum also happened in the trailer. And I would specifically point your honors to page 102 of the transcript during the cross-examination where Ms. Davis was asked, what was the most painful thing? And she said it was the ear. And then the follow-up question is, and you never screamed when that happened? And she says no. And all of the testimony about her not screaming is about what happened in the trailer, because the defense cross-examined her extensively about, well, your father and mother were in the trailer. Your father keeps a gun by his bedside. Why didn't you call out? Why didn't you shout out? And she gives her explanation that she felt threatened that if she did that, it would make things worse. And that, in terms of the car, she never says suddenly, she does say he kept hitting her upside her head, but she never says, all of a sudden I felt this great pain from the ear. That seems clearly to have already, happened at the trailer. So I would say that assault is part of what took place in the trailer and not separate, and not part of distinctly, not the product of a distinct interruption and a second assault. I think Ms. Davis's testimony on page 60 of the transcript, where she says the whole way home he was still hitting me upside the head where I had the ruptured eardrum, also supports that reading. But most importantly, the point is the state has the burden here to prove two distinct assaults with deadly weapon inflicting serious injury. And so even if we're left with pure speculation about whether the ruptured eardrum was part of the sequence of events in the trailer or in the car, that would also not meet the state's burden of proof here. And I see that I'm well into my rebuttal time, so unless there are further questions, I will reserve the balance of my time for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
Thank you, Your Honor. Can y'all hear me? Okay, just want to make sure. May it please the court, Mr. Chief Justice and Associate Justices, my name is Wes Saunders. I'm here on behalf of the state of North Carolina, the appellee in this matter. This matter is before the court on defendant appellate's appeal of the unanimous decision of the Court of Appeals, which found there to be sufficient evidence to take the charges of 3 separate assaults, 2 of those being with a deadly weapon, to the jury. Defendant has sought review before this court, arguing that the events of this case constitute only one single assault, and the assault was not with a deadly weapon. The state disagrees. When viewing the facts of this case for sufficiency purposes, this court has to view the evidence in a light most favorable to the state, giving the state the benefit of the doubt of every reasonable inference in fact and evidence. Also, the state has to, in reviewing the evidence, we merely have to show that a reasonable and rational member of the jury could find defendant guilty of the charged offenses based on the evidence viewed in a light most favorable to the state. Because defendant initially talked about the assaults with the deadly weapon with the fist, I'll begin my own presentation with that. Defendant argues that there's insufficient evidence that he wielded his hands and fists as deadly weapons in this matter. Now, when the deadly character of a weapon is certain, it's a gun, it's a knife, the trial court can make that decision for the jury. But when the deadly nature of a weapon is uncertain, that's ultimately a question for the jury to determine. Now, whether a question is deadly or not oftentimes depends on the manner in which it's used and the condition of the parties assaulted. And that's what State v. Wallace held. Now, a deadly weapon need not actually kill or likely kill someone. It can merely be found deadly due to its likelihood that it could cause great bodily harm in the circumstances. As this court stated in State v. Sturdivant, no item, no matter how small or commonplace, can be safely disregarded for its capacity to cause great bodily injury when it's wielded with the requisite evil intent and force. In this case, defendant was charged with 2 counts of assault with a deadly weapon. The first count for repeatedly punching Ms. Davis in the face, resulting in a fractured nose, and the second count for repeatedly punching her upside the head in the vehicle, resulting in a ruptured eardrum. Ultimately, this is a question that's left to the jury after viewing the facts of this case in a light most favorable to the state. Looking at the state's evidence, the facts show that defendant was intoxicated, had been drinking all day. According to Ms. Davis, he was acting crazed and possessed. He delivered countless blows to Ms. Davis's face, both in the bedroom and in the car. He was larger than Ms. Davis, a fact that defendant even acknowledges on page 28 of his brief. He assaulted Ms. Davis for over 2 hours, both in the bedroom and in the car, and he assaulted her to such an extent that Ms. Davis testified she thought she was going to die. Not only did the assault in this case have the potential to cause great bodily injury, but actually did result in such harm. Ms. Davis suffered a broken nose from repeatedly being punched in the face and a ruptured eardrum that required emergency surgery from being punched upside the head in the vehicle. She was beaten so badly that members of her own family who had just seen her hours beforehand testified that they could barely recognize her when they arrived at the hospital. Ms. Davis's sister, when she found her the next morning, testified that Ms. Davis was acting dazed and confused and was still bleeding out of her ear.
Was there anything that the state is contending that is inherently deadly about the usage of the hands and the fists, aside from the duration of the incident and other aspects that you say exist here, such as the size that would make the hands and the fists inherently deadly weapons here?
Yes, Justice Morgan. I believe it relates to the entirety of the circumstances of this case, the condition of the parties, the fact that defendant was acting crazed and possessed. The length is certainly a factor into this. Defendant repeatedly talked in his opening about, a single punch to the face breaking someone's nose. That's not what we have here in this case. And looking at the totality of the circumstances and assault in this case, I think it's apparent that it's reasonable that a member of the jury could determine that defendant was wielding his fist as a deadly weapon based on all the factors that we've discussed here.
Well, for us to give the trial court some guidance, since hands are commonly used in assault cases, where would we as a court help the trial court to draw the line between hands being used as deadly weapons in terms of instructing juries, as in terms of just the inherent danger of deadly force with hands and fists, as opposed to a case such as this one where the duration of and the veracity of the attack allegedly may be more of the factor here?
Yeah, I think the court could adopt a totality of the circumstances standard and could enunciate several factors for the court to consider. Obviously, the size and condition of the parties, the length of the attack, and the severity of the injuries would certainly be factors that I think the trial court should take into consideration. Now, defendant argues that.
Can I just follow up on that?
Yes, Justice.
So then is it the state's position that there are some cases where where there's an assault using hands that could not be sent to the jury on assault with a deadly weapon?
I do believe so, Your Honor. I think the example that Mr. Schatz used, where someone just comes up and punches someone once and breaks their nose. Depending on the totality of the circumstances, I think you could see a situation where that would only be sufficient to charge with assault inflicting serious injury. But what distinguishes assault with a deadly weapon is not just the serious injury, but the circumstances of the injury. In this case, the defendant was significantly larger than Ms. Davis. He repeatedly punched her in the face numerous times. Ms. Davis was incapacitated. The evidence shows that she was physically incapacitated. She was concussed. She testified she was scared. She didn't know what to do. This had never happened to her. She just froze. And she was emotionally incapacitated. Defendant said if she made any noise or tried to get any help, that he would go and kill everyone in the residence, including her parents who were asleep on the other side of the home. So I think it's the totality of those circumstances that distinguishes a run-of-the-mill assault inflicting serious injury and a greater charge of assault with a deadly weapon. Now, defendant also argues that you can't have assault with a deadly weapon when you have two healthy adults. But as we've seen in State versus Sting last year, this court held you can have that. In that case, the defendant assaulted his mother, who, for all intents and purposes, based on the record, appeared to be healthy, when he came up behind her and strangled her until she passed out. The Court of Appeals has also addressed this issue in a persuasive opinion in State versus Grumbles. And that was a case that was very similar to what we have here in this case. It's a domestic assault where the defendant repeatedly punched his girlfriend in the face multiple times, ultimately resulting in a fractured jaw. And looking at the totality of these facts and circumstances in this case, Your Honor, the state's evidence, again, the evidence has to be viewed in light most favorable to the state, supports that there is sufficient evidence where a rational member of the jury could determine that defendant assaulted Ms. Davis and used his hands and fists as a deadly weapon in those circumstances. I do, if there are no further questions on the deadly weapon charges, I would like to turn some attention to the assault charges. Defendant's second count for error in this case alleges that there's insufficient evidence that he committed multiple assaults. It's defense contention that this was all just one continuous assault. As defendant mentioned, this court has previously decided in State versus Rambert a test, which I again acknowledge is not an assault case, it was a discharging of a weapon case. But State versus Rambert sets forth a factorial analysis that this court used to determine whether the actions in the case constituted separate conduct. And after Rambert and its
can you talk with me about how, the only thing I'm convinced of after having looked at the materials in this case and the relevant legal authorities is that the law in this area could certainly use some clarification. And I don't think anybody would disagree with that. Is the state, on the one hand, you have the, continuous assault theory that's been espoused, I think, in the Plimps case. On the other hand, is the state contending that every blow in a multi-blow assault case is a separate offense?
No, Your Honor, we're not.
All right, so, and I didn't think you were. So, are you saying then that each different injury is a separate offense?
No, Your Honor, I'm not. The state's not contending that as well. I think you have to consider the factors that this court sets forth in Rambert. Do you have evidence of a separate thought process, which the Court of Appeals, in applying their test of Rambert, has found that's evidence when someone transitions from a different means of attack. For example, going from punching to choking or punching to beating someone with a baseball bat. Also, is there are the assaults or conduct distinct in time? Was the person simultaneously punching them multiple times?
I've read Rambert, and the concern I've got is, technically, to go back to my first example, and I didn't think you were contending that, but for example, each punch, there's a temporal break between the punch. Each punch requires a separate voluntary act on the part of the actor to do that. If you read Rambert literally, doesn't it get to that result?
I think you could get to that result depending on the circumstances. If someone punches someone, takes a walk around the block, comes back and punches them again, certainly that could be a separate assault and justify it. Just looking at the second Rambert factor, the distinction in time between the two assaults. I don't think you'll see that in a case where someone's just repeatedly punching someone over and over again, which we had here in this case. You know, the state did not charge defendant with every blow in this case. If we had, he would have faced far more considerable charges than the 3 assaults he was convicted of.
But I do think we have to worry about, if, we can't just turn this issue over to the charging decisions made by district attorneys. I mean, I think we do need some standard for determining what is and isn't a separate assault. And, if the standard is, if you agree that it's not each separate punch or each separate injury, how do the Rambert factors help us get to the result that you think to be appropriate, at least as a practical matter?
Yes, Your Honor. I think Rambert helps here because it's a factorial approach. You consider the, is there evidence of a separate thought process? Is there evidence of some distinction in time between the 2 injuries? And did the injuries or did the conduct result in injuries to different body parts? I think you can get to that by applying this analysis to cases. For example, if someone's repeatedly punching someone, there's no distinction in time between the 2. But if someone punches someone,
why not? Because each punch requires, it might be 3 or 4 seconds difference, but that's a time difference.
Well, I think that's when the first factor would come in and distinguish that action by determining whether there's a separate thought process. And I know each punch could be a thought process in and of itself, but as the Court of Appeals has applied Rambert, they really look at, is there a different mechanism of injury? For example, in the Harding and Wilkes cases, the victim was being punched repeatedly by the aggressor, by the defendant, but the defendant wasn't charged with multiple counts of assault for each punch. He was charged for separate counts when he changed his mechanism of attack.
And I guess I'm less concerned with the actual charging decisions made by the district attorneys than I am with what are the legal limitations on those charging decisions, if any. And so you repeatedly refer to the fact that the DA didn't charge various things, but the question really is not what the DA did, but what the DA could do, isn't it?
I suppose, Your Honor, and I think that's where it would be the responsibility of the trial court to apply the Rambert factors and determine when defendant files his motion to dismiss whether there actually is sufficient evidence based on the facts.
And I guess I'm trying to understand how that if you apply the Rambert facts, you don't get to the result, the factors, you don't get to the result that every punch is a separate assault.
I think when we look at how the Court of Appeals has applied Rambert, we haven't seen that situation before. I think that's indicative of how the Court of Appeals and Rambert has been effective in.
Can you give me a sort of a theoretical construct for how you apply the Rambert factors in such a way that it doesn't produce that result?
Yeah, I think so. When, again, applying the first Rambert factor, the Court of Appeals has typically looked at, is there a different mechanism, a different means of assault between the 2? For example, in the Harding case, the defendant went from punching the victim in the face to choking her. And that transition of means of assault was sufficient to separate out those 2 means of attack against the victim. And that's why they didn't charge the victim. And that's why the defendant wasn't guilty of multiple assaults for punching the victim repeatedly in the face. So I think that change in mechanism in the first Rambert factor is what allows the court to apply and distinguish out multiple punches in this hypothetical from being separate counts of assault.
Does the state agree with the defendant that all of the assault charges arose from the incident in the vacation bedroom?
No, Your Honor. I think the evidence is pretty clear that there was a separate and distinct assault. I think the 3 assaults in question are separate and distinct from one another, but I think it's clear that the assaults that took place in the vehicle were separate and were distinct. The evidence shows that after defendant made Ms. Davis clean up and remove the blood and vomit stained sheets from the bed, he then had her pack up her things and forced her into the passenger side of her vehicle where for the next 2 hours driving through Eastern North Carolina, he repeatedly punched her upside the face, the same side of the face where she suffered a ruptured eardrum.
Well, while there was assaultive behavior allegedly in the vehicle on the trip to Sims, the defendant states, at least in his brief, that all of the alleged assaults took place that were charged in the bedroom there at the vacation trailer. You take a different view and say that some of the charges formally that were made for assault emanate from the trip that was back to Sims?
Yes, Your Honor, and that goes to the sufficiency of the evidence. Again, for sufficiency of the evidence purposes to survive defendant's motion to dismiss, the trial court has to look at the evidence in light most favorable to the state, giving the state the benefit of every reasonable inference and tie from the evidence. Evidence, as defendant talks about, it could, point to that assault on that ruptured eardrum injury being sustained in the residence. But there's equal evidence supporting that it could have occurred in the car. And ultimately, that's a question for the jury to decide after the state has met our sufficiency standard.
Is the eardrum injury the only one that could be in that position as to a jury determining whether or not it came from the vacation bedroom or whether it came from the vehicle ride?
There was another charge of assault by strangulation that defendant was found not guilty of. There was testimony that Ms. Davis was strangled both in the residence and in the car. But since the jury found defendant not guilty of that charge, it's not really relevant to discuss here today. But I do think as it relates to the other assault charges, the assault on female where defendant grabbed Ms. Davis and headbutted her, and the assault with the deadly weapon by repeatedly punching her in the face, resulting in facial fractures. The evidence clearly supports that those occurred in the residence. The testimony about her being assaulted on the car ride home, it's my understanding, only consisted of her being punched on the side of the face.
Do you agree with the defendant's depiction today as to the nose injury and where that stands about a bite versus a punch?
Yes, Your Honor. I think the evidence, I know she was bit on the nose based on her testimony, but I don't know if there's any evidence. Certainly that could have resulted in the fracture, but I think it's more likely based on this evidence it was from the repeated punching to the face.
In the bedroom?
In the bedroom, yes, Your Honor.
Okay, thank you.
Now, defendant talks about, when the Court of Appeals has applied Rampart, defendant argues that the Court of Appeals is actually split. Sometimes they apply Rampart, sometimes they apply this distinct interruption analysis. The state actually thinks it's our contention based on reading the cases that these are actually consistent with one another. I think when you view the evidence, the state's, when the Court of Appeals applies the distinct interruption test, they're merely using that as a factor in the second Rampart factor, determining whether the assaults were distinct in time from one another. When you look at Rampart's progeny at the Court of Appeals, I see the evidence falling in one of three categories, these cases falling in one of three categories. On one hand, you have cases where you have direct evidence, the victim testified about everything that happened to them, and that evidence supports multiple assaults. In middle ground cases, which I actually don't know if we've actually seen, but I think you could imagine a situation where you don't have testimony from a victim, but you do have extensive physical evidence, medical evidence, indicating that there were separate assaults that took place. In the third group of cases, the cases that defendant cites too heavily, the McCoy-Brooks and can't remember the other cases, or Maddox cases, those are cases where you had no testimony. Witnesses and the victims refused to testify, or the victim was beaten so badly that they either could not remember or were unconscious during their attack. In those cases, in that third category, because there's no evidence of the attacks being distinct in time or distinct from one another in any regard, that's why the Court of Appeals just looks at that distinct interruption and says there's no evidence, even in light most favorable to the state, therefore there's insufficient evidence for his charge to go to the jury. This case falls in the first category of cases where we also see the Wilkes and Harding cases. In Wilkes, again, the defendant was assaulting his wife by punching her. Their young child came into the room with a baseball bat to try to defend his mother. The defendant turned his attention, grabbed the bat, and immediately began resuming attacking his wife with the bat. In that case, the Court of Appeals applying Rampart said there's a different mechanism of injury, in the conduct in this case, which reflects a different thought process. There were different injuries from both the punches and the baseball bat hits, and they were distinct in time because the defendant was not simultaneously punching her and beating her with the baseball bat. In Harding, we have a similar situation to what we have here. The victim was thrown down an embankment. The defendant jumped on top of her and began punching her in the face. When she screamed for help, he stopped punching her and began choking her. In that case, the Court of Appeals applying Rampart found that there was evidence of separate criminal conduct, a separate thought process, because the defendant changed his means of attack. They were distinct in time because there's no evidence that he was simultaneously punching and choking her at the same time, something that would have been physically impossible in that situation. And there were different injuries to her face and her neck. In this case, the evidence shows that aside from what happened in the car, in the bedroom, the state's evidence shows that once Ms. Davis went into her bedroom, she sat on her bed, the defendant approached her and repeatedly began punching her in the face. He called her a slut, said she had embarrassed him, and said he was going to kill her. Ms. Davis testified. Fortunately or unfortunately, she was conscious throughout this whole assault and was able to testify what happened to her. She testified that she was beat for over 2 hours, where the defendant repeatedly punched her in the face, bit her on the nose and ear, kicked her, pushed her face down into the bed, holding her arm behind her back, strangled her until she vomited, and grabbed and headbutted her. The evidence shows that Ms. Davis was told if she called out for help, that defendant said he would kill her and everyone in the household. As to the two assault charges, the assault on female via headbutt in the bedroom and the assault from repeatedly punching Ms. Davis in the face in the bedroom resulting in the facial fractures, the evidence indicates that there's no evidence that these were distinct in time from one another. Or that they were part of the same continuous action. There's no evidence that defendant was repeatedly punching her and headbutting her at the same time. Also, defendant employed different means of attack, separate conduct in this case. He went from punching to headbutting, a separate means of attack, indicating that defendant was employing a separate thought process. And finally, the injuries in this case, or the conduct in this case, resulted in separate injuries. We had injuries to her face from the punches, the facial fractures, and we had a hematoma, a large gash on her forehead, and a concussion from the headbutting.
Can I just ask a question? I want to make sure that I understand your argument about whether or not there are two separate lines of cases in the Court of Appeals. And are you saying that distinct in time and a distinct interruption are the same thing?
Yes, Your Honor. I think they're part of the same analysis for that second Rampart factor.
Well, I understand you're saying they're the same analysis, but they're different concepts, right? I mean, the fact an interruption is a different concept from a lapse of time, right?
Correct.
And so isn't lapse in time a lesser standard than some distinct interruption?
I think it depends on the circumstances, Your Honor. In this case, you can see an interruption, I think, and a lapse of time merely by the transition between punching and headbutting in this case. The Court of Appeals, especially applying the Rampart test, has stated that if the mere act of pulling a trigger can be a separate thought process and can be distinct in time, then certainly changing of the methods of assault, from in this case going from headbutting to punching, can also constitute a distinct interruption and a lapse in time. A lapse in time can certainly be much broader. I will contend that as well. Now, defendant argues that, again, as we've discussed here, that the result of this case and Rampart is we're just going to end up prosecuting every single blow that's thrown in a fight. But that's not what we're doing here in this case, Your Honors. If that was the case, defendant would have faced far more charges in this matter than the 3 assaults he was convicted of. What the state is contending is that when a criminal defendant assaults another by using separate and distinct methods causing different injuries, such actions should be considered separate criminal conduct, and the defendant should be separately charged accordingly. In sum, viewing the facts of this case in the light most favorable to the state, there was sufficient evidence for members of the jury to determine and conclude that defendant committed 3 separate assaults. If there are no further questions, Your Honor, I'll just ask for a brief time to conclude. Wherefore, Your Honors, the state requests that this court find that defendant had a free trial or fair trial, free from error, and that his convictions be upheld. Thank you.
Thank you, counsel. Rebuttal.
May it please the court, I just have a couple of quick points to make. First, if I understood the state's argument correctly, the state is contending that the assault with a deadly weapon inflicting serious injury with regard to the ruptured eardrum took place in the car. And if that's correct, we don't have a dispute about the law, we have a dispute about the facts. Because I will concede that what happened in the car, there was a distinct interruption from what happened in the trailer. But I don't think there's evidence that the ruptured eardrum occurred in the car. And I think the way the state phrased its point is very telling. The state said there's equal evidence that it could have been in the car. And that means it's speculation. Now, I don't even think that's correct. I think the evidence strongly points to the ruptured eardrum occurring in the trailer, and I don't think it's equal. But even if that were the case, I don't think that gets to the state to meet its burden of proving two distinct assaults with a deadly weapon, or proving that assault took place in the car, I guess is what I'm trying to say. And then with regard to the state's description of the circumstances that would allow the fist to be used as a deadly weapon, I think here the state kind of wants to have its cake and eat it too, because for purposes of multiple assaults, the state is saying these are distinct things, but for purposes of whether the hands and fists were used as deadly weapons, the state is asking the court to take into consideration the totality of the circumstances of the entire incident in the trailer. And if they're separate assaults, you have to look at how the implement was used in the particular assault in which it's charged as a deadly weapon. So I think that, I think the state's argument kind of falls short there. And I see that I'm basically completely out of time, so I would simply ask this court respectfully to reverse the Court of Appeals and remand for further proceedings. Thank you.
Thank you, counsel. Thanks to everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.